So once again, here we are with another, I'm going to call it a fail. This young man went into a court and got trespassed from it. And there seems to be, again, a continued mistaken belief that just because some place is open to the public, that you can film there. So no judge can make up laws in public place. In a public place, taxpayers, public buildings not off limits. He's in public lobby, a public lobby paid for by the public. Even your public president could not order him away from the public lobby, especially just for filming. Well, as it happens, judges can and do. So our first stop is Estes versus Texas. It's a U.S. Supreme Court case from 1965. Estes v. Texas. From Estes v. Texas, it says, and I quote, "As a result, at this time, those safeguards do not permit the televising and photographing of a criminal trial, save in 2 states, and they're only under restrictions. The federal courts prohibited by specific rule. This is weighty evidence that our concepts of a failed trial do not tolerate such indulgence. We've always held the atmosphere essential to the preservation of a fair trial. Most fundamental of all freedoms must be maintained at all costs. Our approach has been through rules, contempt proceedings, and reversal of convictions obtained under unfair conditions. Here are the remedies." So this guy, his trial was recorded. Now, the next question is, what about the lobby itself? The problem with that is, again, it goes back to the same considerations. Most states do prohibit, most states and municipalities do prohibit filming and photography in lobby areas. And that's due to the reason that lawyers tend to talk to their clients out in the hallways. They'll step out of the courtroom into the hallway and have a discussion with their with their client. The lawyers will, and that discussion has to be open and honest and frank. And the lawyers and the clients may be discussing things that could incriminate them or harm their case or things like that. And the wonderful thing about recording devices, cameras and stuff like that, is they have zoom. You could zoom in, read lips, heightened audio recording. You can capture things when the lawyer is speaking to his client and he believes that he's out of eye shot and earshot of onlookers and other observers. He doesn't know. So the whole point of restricting media, restricting specifically audio and video recordings in courthouses, is to protect the full and fair trial. I always bang on about the public forum. In other videos, you may have noticed, what's a traditional public forum, what's a limited public forum, what's a non-traditional public forum. And we've got here United States versus Grace. In this case, the young man, or the young men, I suppose, were trying to leaflet around the court. And the court held that, surprisingly enough, the court is a non-public forum. Now, because this particular statute extended all the way out to the public sidewalks, they said the statute was unconstitutional because, once again, they have found that sidewalks are a traditional public forum. But for those of you who still bang on about the, the public lobby, public place, taxpayer funded, US v. Grace does tend to put a hole in that. And once again, let me just scroll up here. So you see this is a US Supreme Court case, United States v. Grace. So I'm not pulling this out of thin air. This is actual law by the actual Supreme Court. The First Amendment provides the Congress shall make no law abridging freedom of speech. There is no doubt that as a general matter peaceful picketing and leafleting are, protected by the First Amendment. It is also true that public places, and this is in quotes, public places, it's using this as a term of art, historically associated with the free expression or free exercise of expressive activities such as streets, sidewalks, and parks, are considered without more to be public forums. In such places, the government's ability to permissibly restrict expressive conduct is very limited. The government may enforce reasonable time, place, and manner restrictions as long as the restrictions are content neutral, narrowly tailored to serve a significant government interest, and leave open ample alternative channels of communication. Additional restrictions, such as the absolute prohibition on a particular type of expression, will be upheld only if narrowly drawn to accomplish a compelling government interest. Publicly owned or operated property does not become a public forum simply because members of the public are permitted to come and go at will. Although whether the property has been generally open to the public is a factor to consider in determining whether the government has opened its property to the use of people for communicative purposes, it is not determinative of the question. We have regularly rejected the assertion that people who wish to propagandize protests or views have a constitutional right to do so whenever and however and wherever they please. There is little doubt that, in some circumstances, the government may ban the entry onto public property that is not a public forum of all persons except those who have a legitimate business on the premises. And that legitimate business doesn't mean, oh, my legitimate business is protesting, my legitimate business is filming. No, it means actually engaging in the business that the government set that property up to run. So we continue. The government, no less than a private owner of property, has the power to preserve the property under its control for the use to which it is lawfully dedicated. Now it goes on to say, it's argued the Supreme Court and its grounds and buildings fit neatly within the description of non-public forum property. They don't have to reach that because the sidewalk, because the 13K, Section 13K, they don't have to reach whether or not the Supreme Court building and grounds fit within it, because that law is already tossed out because it covers public sidewalks. However, they make it pretty clear that it is, although the property is publicly owned, it has not been traditionally held open for the use of the public for expressive activities. The property is not transformed into public property merely because the public is permitted to freely enter and leave the grounds at practically all times, and the public is admitted to the building during specified hours. But because under this view, it would be necessary only to determine that the restrictions imposed by 13K are reasonable in the light of the use to which the building grounds are dedicated, and there is no discrimination on the basis of content. They need not make that judgment at the time because 13K covers public sidewalks as well as building grounds inside the sidewalks. As will become evident, they hold that 13K may not be applied to the public sidewalks. So what they're saying there is had it excluded the public sidewalks, then 13K would likely be constitutional. But going back to it, just because it is public property does not mean you have an unrestricted right to do expressive activities there, film, picket, what have you. Just because it's open to the public, just because it's publicly owned, those don't mean that you get the right to do it. And as you see here, they're talking about the court Estes versus Texas, Again, they're talking about the court, and they put it in terms of the 5th and 14th Amendment due process. Basically, you can't, you can't film in there because it taints the fair trial process. So, I hope that makes it clear. The First Amendment is not completely unrestricted. When it butts up against due process does win. The accused has the right to a fair trial, and that fair trial can get tainted. Now, I will go on to say that in Texas, you do have some rights to record court proceedings. So, in a civil trial, Rule 18C says the trial court may permit televising, recording, or photographing of proceedings in the courtroom, not the courthouse, in the courtroom only in a few circumstances. So it starts off with it is restricted. The trial court may permit it. They don't have to. They may. May is permissive. They don't have to. They may permit it. And then in appellate courts, it appears. I would have to research it. I am not a member of the Texas bar, so I guess I could research it, but it doesn't really matter. It appears that that appellate court proceedings in Texas, it doesn't matter apparently if they're civil or criminal. So I guess they could permit it. An appellate court may permit courtroom proceedings to be broadcast, televised, recorded, photographed in accordance with this rule. Again, it is permissive. They may permit it. They don't have to. It would be for the courtroom, not the courthouse. If you Google around, you will find out that Texas does not allow in any of its courts recording. If any of its courthouses, it doesn't allow recording. So feel free to challenge it if you want to. If you've got the time and the money, go ahead and get arrested for criminal trespass in Texas for recording in a courthouse. I'm not giving you legal advice, by the way. But if you want to challenge it, that's the way you have to do it. You do have to get arrested for filming in a courthouse, and then you will have the opportunity to challenge the constitutionality of that, of the courts saying that you can't do it. Another thing, this is just real quick, and I do apologize about it, but they said the judge can't make up laws. That is patently false. Judges do make up laws. Judges decide what laws mean, and whoever would have saw right to privacy, meaning that the state can't ban certain abortions. I certainly would not have seen that coming, but apparently judges did, and one could very well argue that they made up law whole cloth. Another fun way that judges can make laws is injunctions. They can make an injunction against filming. Now, another court, a higher court, could overturn that injunction, but until that happens, like I don't know if you're aware of this, but weirdly enough, and I don't know how this happened, but the Trump's ban on immigration from those 7 nations, they were challenged, and judges filed injunctions, or not. They didn't file. They approved injunctions against the federal government to enforce those travel bans. So that is definitely lawmaking. Now, I guess they were overturned. I haven't looked into that because I don't really follow that, but there you go. So yes, judges can make up laws. They do make up laws, and they can apply it to public places. And even if you're not like a member of that, of whatever group Like, even if you weren't aware that an injunction has been made against doing X, Y, and Z in place A, B, and C, you would still be subject to that injunction. So sorry for rambling, but there you go. I hope you enjoyed my dog snoring next to me, and have a great night.